Anytime an insurance company seeks to change its rates or its forms, it must adhere to the requirements of the particular state in which it is doing operation. And so basically an insurance company would go to the insurance department in that particular state and would need to know what type of state that they're operating in and adhere to those standards and those policies. So each state has its own unique ways of granting approval for new rates and forms, and I just want to go over 4 of those here briefly today. So insurance company A wants to up their rates, change their rates, introduce new forms. They go to the insurance board or insurance department of the state they exist in, and let's say it's a prior approval state. Prior approval state. In a prior approval state, the insurance company must submit the changes it wants to make to its rates or its forms, and the state must approve those before those rates and forms can go into effect. So the insurance company operating in a prior approval state wants to be far-sighted. They want to think ahead and say, okay, we want to change our rates to this, we want to change our forms to that. Let's go to the insurance department and present our case, get their approval, and then we can institute the changes. So that's a prior approval state. All right, insurance company A also does business in a file and use state. In this case, the insurance company is permitted to change their rates and change their forms as long as they comply by filing those changes with the state within a certain time period after the change takes effect. So insurance company A says we're going to up our rates or change our rates and change our forms. We'll put it into effect, and within a certain time period after putting it into effect, we will be certain to file that change with the insurance department. So we've got prior approval. You can't change until the state says it's okay. File and use, you can change it right away. Just make sure it's filed with the state within the given time period so that they're aware of the change. In a file and use state, though, here's what you run the risk of. You make the change, you file it within the specified time period, but the department in that state has the right to come back later and either approve or disapprove that change. So you may put it into effect for a certain period of time, and then the department can come back later and say, I'm sorry, we don't approve that change, and you've got to go back and fix it. So there's some risks involved as well as rewards in a file and use state. In other states, mandatory states, basically this says, don't even bother talking to us. The state mandates what you will charge as rates and what forms you will use. It is mandatory in that state. You can't make changes to it. Basically, it is what it is. Mandatory states require companies to use forms and rates that are already standard in the state. So if you're going to do business in this state, here are the mandatory rates, here are the mandatory forms, and when the state changes the rates and the forms, then that change is then put upon the insurance company in that state. So that's what a mandatory state is. The state decides what the standard rates are and what the standard forms will be to be used. And then in an open competition state, this basically says, feel free to set your rates and use whatever forms you want, but you're in competition with every other insurance company in the state. So you can set them as high as you want, but if no one buys your insurance, that's your problem. So in an open competition state, they permit companies to use the rates that the company selects and compete with other companies then. They still must abide, however, in an open competition state, they still must abide by non-discrimination regulations and adequacy regulations. So just because they get to use whatever forms they want and set whatever rates they want, they cannot discriminate in their insuring someone, and they must offer adequate insurance. So the state provides a minimum of accountability there in terms of discrimination and adequacy, but basically leaves it up to the insurance company to compete in the open market with other insurance companies. So just briefly to recap, in an insurance company wanting to change their rates or their forms in a prior approval state, they submit it ahead of time to the department, who looks it over and approves it, and once the department approves it, then they can put it into effect. A file and use state, basically they can change it whenever they want, as long as after they make the change, they submit the changes within the specified amount of time, with the realization that that department may come back later and disallow it or approve it as it wills. In a mandatory state, you can't change anything if you're going to do business in that state. The state sets the standards for rates and forms. And then finally, in an open competition state, you're competing openly with all the other companies freely, with the one caveat of making sure that you don't discriminate and that the insurance is adequate. Well, that's a basic overview then of an insurance company wanting to change their rates or forms and the different ways that is played out in various states. If you'd like to learn more about this and related matters, underneath this video you'll see a link. If you'll click on that link, it'll take you to that website that has that information. And while you're at that website, you'll find a link to an ebook that's ready for immediate download.